Thank you to all the fantastic speakers, and just generally also to the chairs. It's been really wonderful listening. I have a question that came up in Moreno's presentation, but it's actually also a question geared towards the lawyers, so I don't know who will answer it. You talked about the high-emitting countries and the vulnerable countries that bear the brunt of the consequences. And yet, going back to attribution science as well, we have science that clearly indicates an increased number of deaths as a result of, for example, heat waves in the countries that are high emitters, but perhaps not the most vulnerable climate-wise. So my question is, and this goes also to the overall question of, are human rights courts the right forum for bringing climate cases, etc.? Is one death or, say, a number of deaths sufficient to claim under these rights? So I don't know if that question makes sense, but basically, where do we set the scale or the impact of what we consider as human rights violations, for example? And what comes to mind as I reflect on it is the fact that perhaps human rights courts are precisely really useful for a European context, for example, or other contexts where vulnerable countries are not necessarily in place, but we have high-emitting countries, and we do have deaths arising from emitters. So I don't know who wishes to answer that or comment on that.
I can give you a first answer because mine is going to be very quick. If you're asking me how many deaths are required in order to be worried about the effects of climate change, I'm not going to answer. I'm a scientist. I have no idea. All I can tell you is, we start to have evidence that many people are suffering and their health is at risk, including at risk of death for severe malnutrition because of reduced food production, for example, because of the effects of climate change. Then there is the direct implication of heat waves, and all of those things should be of concern. How you measure those things, how you make decision on those things, that's very much a legal question, in my opinion, not a scientific one, so I'll pass to my colleagues.
I'm happy to just bring a perspective from a study I've seen. The emissions of equivalent to the equivalent to the lifetime emissions of 3.5 average Americans causes one excess death globally, an expectation between 2020 and 2100. So there are also metrics to quantify. There is attribution to quantify the responsibility of individual in contributing to excess death.
Go ahead. That's very kind. Well, I don't want to be manspreading. So my name is Guillaume Parent. I'm working for the Parliamentary Assembly of the Council of Europe. And the Assembly is mobilized to push back the Council of Europe on environmental rights. Let's say that 50 years ago, the Council of Europe was very much forward, and they took part in the Stockholm Convention in 1972, pushing for already a right to a healthy environment. Our Assembly has witnesses the withdrawal of all those aspects inside the Council of Europe. So basically, now we have like the shadow of our activities. We still have the Berne Convention, we still have the Landscape Convention, we still have this major hazard agreement. But basically, our capacity are very much limited. They were cut off for the last 20 years. So now we have, at the pace again, we are pushing for bringing back the organization on this issue. And for that, we are pushing again for an adoption of a protocol to the European Convention of Human Rights. So for us, it's important. I understand that it's only a tiny part of the activity of the court, but for the pace, it's important because it responds to the pressure coming from outside of the court, outside of the parliament, and responding to people angry around in the society, and respond to the pressure which is actual of the climate crisis. Our second objective is also to push for a new instrument something which would include another monitoring tool on the model that we have already available at the Council of Europe. So we have the Greco, the Group of States Against Corruption. We have on racialism, on trafficking. We have on domestic violence, violence against children. So our objective is to take advantage of the experience of the organizations in terms of peer cooperation, and trying also to respond to all the real actual threats. So for that, this network was established 1 year ago. It will have its 9th meetings next month, in 2 weeks from now. So, we have worked on strengthening the capacities of parliamentarians on various issues linked to the tools actually available at the Council of Europe, but also other things. And this morning we discussed about IPCC reports. If I'm not a lawyer, I'm not a scientist, I'm just a politologist, and those reports are really difficult to understand. And even those summaries, which are normally adapted for political advisors, they are difficult to catch. So our task at the network was to help to bring the issue to the politicians, bring the issue to the elected representative. So we have this objective. We have also the objective to bring the discussions of climate crisis inside the parliament. So thank you, Mr. Robiou, for your presentation. It's exactly what we are expecting to do, and we also discuss on a very difficult issue like this treaty on the energy charter, which is a complex issue. So really I advise you to follow our activities. We have a tiny portal on the website of the Assembly of the Council of Europe. So thank you.
If I can just say on the summary for policymakers of the IPCC has to be approved by all governments. So that also explains why there might not be the level of details that some of us would want to see in it. But yeah, you can certainly reach out also to scientists so that they can tell you what didn't go in there, but it's still science-based.
Hello. First of all, I want to congratulate for the excellent panels we saw today. And actually, my question is really related to his question, because when I was reading all the data, all the information you presented to us, Professor Yam, I was a bit conflicted, because even for us, we come from the science and law field, we have this privilege of somehow understanding better what is presented to us. But how would you translate science and climate data to make it more accessible to community, to international society, not international society, but to normal people, so saying, so they can understand better what's going on, and they can also start to act? Because I have this question, because I worked for 2 years as a law professor, environmental law professor in Brazil. And it was quite difficult because it was during Bolsonaro presidency. So his government was a bit messy for us in the environmental and human rights field. And it was a bit difficult because some students, they were also flagging what the government was saying, like, oh, no, climate change is a hoax, no, it's not real, it's not changing, etc. But we have science, we have data. So how could we translate to become it more accessible so people can finally understand what we are saying? So that's my question, and thank you.
Yeah, part of my activities is also to do dissemination. I think I hope it is understandable. I do teach, so I hope it's possible to understand what I teach. But there's also, I meet a lot of stakeholders who really understand these questions really well. For instance, diplomats, whether they come from countries that choose or choose not to engage with those questions and to follow the scientific recommendations, they do understand it really well because it's a necessity in international UN negotiations. So it is understandable even for people who are not coming from this field. But then, it takes time. It takes presence. I can speak for France, where these questions are not discussed publicly, even also by NGOs who pursue climate justice internally, but don't really discuss international climate justice. So there's a whole question of access to experts, the presence of science, and I think this goes beyond my expertise, but I think, social scientists also working on denial, on working on how to different society engage with science. So I don't know if other people in the panel have takes on this, but I believe what I presented, I believe is understandable with a bit more time.
Thank you for that point. That's really, really important. Also in terms of that, if we're going to address climate change, we need to include all sectors of society, and all groups of, different groups of people need to be part of this discussion. And so I think part of the challenge from the scientific side is to find, ways to engage, not just people in lawyers and judges, not just politicians, but also regular people. And I think maybe a starting point can be to see how people in different parts of the world are affected by climate change, because these days probably everyone on the planet can feel the effects in one way or another, whether it's rising temperatures, more extreme storms, or melting glaciers in mountainous regions around the world. And so I think oftentimes people might have an understanding of what's going on, but they might not think about that so much in terms of global climate change. And so I think the communicating climate change and climate knowledge isn't just about telling people what's happening, but it's also about listening to people's perspectives and gaining other perspectives. And I think science in that sense has a lot to learn as well. For example, from indigenous perspectives on climate change, which indigenous knowledge, which goes is much broader, goes beyond kind of the pure scientific facts of how many degrees the temperature is changing, or by how many meters a glacier is retreating. There's a lot of indigenous knowledge about how that affects a local ecology, how that affects the way people engage with the environment, with animals, with plants, and things like that. So really, what we need is a broader discussion on this, and everyone should be a part of that.
Well, thanks very much to all of the speakers. Judge Katistakis, apologies. In your remarks earlier, you were talking about sources of peer-reviewed scientific evidence and the role that plays in the legal system, and you said it was important that there was sort of in the peer review process there's a broad representation of sort of diverse views from within the scientific community are reviewing the papers. But when you and your colleagues are presented with evidence, often you don't know who the peer reviewers are. You have to trust, presumably, that the scientific journal chose good people, and usually the process that they would go through isn't necessary to choose necessarily a broad diversity of scientists, but experts who are essentially credible experts who can really evaluate the methods and the conclusions. And would you see that as sufficient, or do you feel that in the process of adjudication you would need to know more about the process that an individual paper has gone through in order to be able to trust the robustity? And I know you said you would do your own evaluation, but could you expand a little bit on what that would look like?
Of course, Of course, yes. Of course, we need more. We need more information, more knowledge about the issue, and of course, some the last years, I can say that, and I think the Inter-American also Court of Human Rights is on the same direction. The European Court accepts almost all the demands for third interventions in case before the court, including the environmental cases. And the idea of the third interventions, according to the Latin phrase, is amici curiae, the friends of the court, the friends of the justice. And we are looking with these third interventions to have scientific contribution to our work. This is the meaning, anyway, of the relevant procedural, let's say, occasion to present to the court, like a third intervenant, the aspect of in different cases. This is not exactly the cases in ICJ. They are not the amici curiae are not really present there. In contrary, in the International Court of the Law of the Sea, there is a special procedure, and there is also a transparency of the contribution of third intervenants. As you listen, and I listen also from Professor Keller, my former colleague, there are no funds, there are not budget for this reason in our court in cases to ask, let's say, a specific scientific contribution, but we are always looking for the contribution of the third intervenants in our case. May I say something? Well, it's not our work to prepare a additional protocol, but it is important to say that, in my knowledge, the vast majority of the contracting parties have a special constitutional provision for the protection of the environment. Concerning Greece, has a special provision since 1975, just after the dictatorship, and this provision has really contributed the major to the development of Greek environmental law and the environmental case law. But I think also it is important to mention that Article 37 of the Charter of Fundamental Rights has also provides also the right to environment, and I think it will be really a step forward to have a provision, certain specific provision on right to environment by additional protocol in the European Convention of Human Rights. Thank you.
Well, then I have a question for you, if no one else. One of the points in my talk was that sometimes the range of results from various studies can give the impression that it's inconclusive or that there is no agreement amongst the science, and my point was that it's not the case. From a judge perspective, do you think some cases can be not considered because of that, because it seems that science is inconclusive? And if so, how do you think either the science, or what do you think can help make that this body of science is considered for litigation cases?
Yes, Well, I will try to answer to your question, and I want to say that the procedure before the international courts are on the hands of the two parties, and as I explained to the ICJ case, it was Australia, the defendant state, who decided to propose this approach about the evaluation and the review of the scientific program of Japan. And the court accepted this option than the other options that provided by Japan or by New Zealand, who was an independent state. I want to say that the parties will have the task, the duty, the obligation to provide to the national court the scientific results in such a way that the court will not have trouble with the different numbers and the different let's say conclusions, the most of the time conflicting conclusion by different scientific evidence. But let's remember the procedure. The procedure is that the applicant complain for existing specific research. This is the beginning of the difference between before and the national court. I mean, the scientific research for which there is a complaint is the basis of the discussion. Then the International Court of Justice proceed, as I explained, to this review according to some criteria. The other scientific research provided by defendant or even for third defendants, they are not in the center of the dispute. The dispute is probably a scientific research. Thank you.
If I may complement, from the perspective of the legal framework of the current legal framework of the European Court of Human Rights, the principle of precautionary principle of international environmental law can operate, and we have stated it for the first time in Tatar, didn't use it correctly really, but whereas the applicant has to prepare a prima facie case and argue that there is an arguable claim to be exposed to risk or to have suffered harm, then theoretically the precautionary principle tells us and allows us that the burden can shift. So we know that it operates in international environmental law, has never operated before the court in environmental cases. It does operate in cases of ill treatment or medical negligence where we don't have access to information because of objective reasons. So this shifting of the burden otherwise operates in the case law of the court. And we know obviously that the convention is a living instrument and has to be interpreted in light of international corpus juris. So the precautionary principle, which is based on scientific uncertainty, was just triggered by scientific uncertainty, is not something that is completely unfamiliar or novel to the court.
First of all, thank you. And I just wanted to ask a question in regards to the benefit of maybe like a new protocol or a new provision in the European Convention of Human Rights. What would this bring that the current article cannot cover, I would say? And because I think like currently it's more under Article 8, Article 2, or so yeah, what would this bring like more? And do you think that it may be possible that like a lot of states ratify this new protocol, or we may have a problem in terms of ratification of the new protocol? Thank you.
Well, as Nathalie has also explained on the first panel, there is a convention is a living instrument, and there is this dynamic interpretation of the articles of the convention, and I can have many examples of articles applied to environmental case law. Is even Article 1 of the first protocol about right to property, Article 11, Article 10, then there is this case law that the court has developed this case law from 90s until today. But when there is a specific provision, there is also there's always this let's say obligation under international law to apply the specific provision, and I think that always there is a need of specific provision of the right to guarantee this right. And I don't know about the ratifications, but it can go in parallel. I mean, already there is the case law, and there is this binding force of the case law. Well, according to the convention, the binding force is between the parties, not between all the 46 contracting states. But of course, we know the influence of any judgment delivered by the court. And at the same time, we can see how if this protocol will be adopted, how the ratification process will continue. But this doesn't mean that there were not, at the same time, the 46 states are not, let's say, binding or influenced by the existing case law and the development of this case law. But the provision is always has this direct effect to the state obligations on question of environmental law.
If I may complement, the main difference of bringing the right to a healthy environment into the legal framework of such as the ECHR would be that the right to a healthy environment has been defined as having an objective and a subjective dimension. And this comes from the advisory opinion of the Inter-American Court of Human Rights, then repeated in a contentious case against Argentina, La Cajon had. And basically there is a consensus among scholars that in an objective dimension, the right to a healthy environment protects the environment and the elements of the environment. So the Inter-American Court actually says seas, mountains, and forests, and animals, and anything that is, and the human being as well. So this is the objective element. It's similar to the French legal framework when you have préjudice écologique, so any kind of disturbance or interruption or destruction of the within the system, earth system, within a particular ecosystem. The subjective aspect of the right is what the environment offers us and the benefits that we derive from the environment. So this, to a certain extent, the subjective aspect, so in other words, pollution harms you and your health and your well-being, this is covered by the current green human rights, indirect protection of human rights under Article 8 to whatever else. But the objective element is not, and this would be something completely new, the objective element of environmental harm. And then, of course, what consequences for the system, there will be, first of all, ratione materia. The environment itself would be the object, not the subject, but the object of protection. And then, of course, questions who can defend the environment, who can bring the case. So there may be consequences which are more or less far-reaching as to who has actually legal standing and so on and so forth. But primarily, it's this. The difference here is the objective element of the right. Otherwise, we are still within the current system.
Hello, my name is Philipp Schönberger. I'm from Green Legal Impact, a small environmental law association based in Berlin. I have two questions, and I try to make it very brief because I think we're running out of time. But the first one would relate to the last presentation of Monsieur Robieux-Dupont, and just that I understood it correctly. That one study that you referred to about the equity approaches, and that is the outcome of that study that if every country follows the most favorable equity approach to its fair share, that we would, for 1.5, that we would end up around 2 degrees in result. And then the question, because I feel that touches a very important issue of climate change litigation, that from my point of view, we've kind of passed a bit that questions of really the scientific basis of climate change and what the effects are, and so we can rely on the IPCC reports. But from a litigant's perspective, I think we always now running into these equity discussions, and I mean it's one of the center arguments in that case is also pending at the court. And I always, and the German Constitutional Court, I think they didn't say so explicitly, but what they did in the end was also to adopt that approach. In the end, they referred to a German fair share that responds to the most favorable, which is per capita calculation of our emission budget. So the question was, and I always thought that is not a way that we can go down, like legally, to adopt just an approach and say, well, every state takes the most favorable one, because then we will end up with 3 or 4 or 5 point degree. But that sounds to me like I was a bit surprised that this is actually the outcome. And then the question would be, how far, like, is there a big range in each approach? Like, because you have 5, 6 different approaches, and how broad is the range in each approach? Like if I say I take the per capita, is then again a huge range, and then in the end I end up with a huge variety of different budgets, and then maybe in the end, in total, globally counted, I end up with, I don't know, a much bigger number. And maybe the follow-up question on that is then, if that's kind of a possible legal argument that you can make, my question would be, but I mean maybe directed to the whole panel, do you see any follow-up problems or risks where this might take us? Because it seems very appealing in the first place to say, well, that's better than to have any standard for that question of fair share, that we can translate it into a legal concept. But is there any follow-up pitfalls that you see? So, and the second question I just skipped.
Thank you. So yes, the study looked at what would happen if everyone followed the least stringent, and the conclusion is that if it doesn't work so as to pursue a goal, so if we aim at 1.5, we get to 2. One of the things we quantify in the paper is that then we could aim at 1.3 and then follow a self-interested manner. The legal interpretation of this is not something I can comment on, but the legal use of the study was to say, yeah, if even if a case like Urgenda was won in every country under the European Courts of Human Rights, it still wouldn't add up and it wouldn't work collectively. So that was the use of it. Specifically for the approaches, yes, in your reasoning, you're right. If we added more in the pool of the approaches we could choose from, it would yield to different results. Yes, you did understand the results correctly. It was in a self-interested application of the way we quantified, so in our study, these equity approaches. There could be other ways. So that was our study. But yeah, then I can go into more detail in the discussion after that. But maybe if someone wants to answer on the legal interpretation of what this would mean, aiming, I don't know. Did I understand that you wanted to hear of the legal implications of aiming lower than 1.5 to actually get to 1.5, or was it something else?
Yeah, more in general. I mean, first, thanks for the answer. I just wanted to be sure that I get this right and don't miss a point. Then the second question would be what would be but if you see any potential in the legal, using this as a legal argument, any potential pitfalls in the long run, if we then agree to this, everyone picks the least favorable, the most favorable, adopts the most favorable equity approach. Does this get us to where we want to get?
So the point of the study is that it doesn't work,
Yeah.
and I think that's what is argued under the case of the Portuguese youth. So it's trying to go beyond ruling that would just rely on a range and the least ambitious end of the range. Because my understanding of the Urgenda case is that the judge didn't want to choose where in the range it should be, and said, but at least you have to, like the Netherlands have to make it possible that it's considered sufficiently ambitious in one of the vision to preserve a chance to reach the global goal. But it's not replicable. So the question is, do we want to have a ruling where it is possible that it can work in the extreme case of where everyone agrees, or do we want a ruling that can be replicable and consistent? But that's just my perspective as a scientist.
Thank you very much. I think we have slowly to conclude. And I would like to thank very much all the speakers of the panel of this afternoon. So I think we can applaud. There are so many topics to continue the discussions, and I think we can continue this with the cocktail. We have maybe also to keep in mind that climate change is only one of the 9 planetary boundaries. So there are still a lot of works for the 8 other ones, and we have seen also the connections between them, especially with Moreno discussing about the biodiversity and the connections. And now I would like to give the floor to Elisabeth and Nelle for the concluding remarks, please.
Thank you. Yes, Nelle and myself would like very much to thank you all for those very instructive discussions. Thanks to the chairs for the work you have done. Thanks to the participants online. We also thank you for the brilliant ideas being shared and raised. Thanks to all of you, and yes, I invite you to the cocktail. Last thing I would like to say is that the videos will be online, so it's possible to vision again the discussions we have had the whole day. And Nelle and myself also hope that there will be a publication out of all those works, so we will see and we will get in touch to you very soon. Thank you.
And thank you very much to you for organizing this event. Yeah.